All right, I think we're on and good to go.
Very well. I'll call this meeting of the Board of Continuing Legal Education Subcommittee on Bias and Diversity to order. I'm George Jenkins, chairing the committee. Committee members present are Judge Linda McGee, Professor Dorothy Hairston Mitchell, Professor Jim Drennan, and Dixon Phillips. And then we have a number of guests that we're happy to have with us as well. Would like to ask Peter, before we start, the members of the subcommittee are hereby advised of their duty under the State Ethics in Government Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or an appearance of conflict. Does anyone know of any conflicts or potential conflicts based on their review of the agenda? None appearing. I'll turn the meeting over to Peter.
Mr. Chairman?
Yes.
You know, I'm a 71-year-old guy who teaches this topic from time to time. I don't know if that makes, or what could be construed as this topic from time to time. I don't know if that constitutes a conflict or not.
I would think not.
I don't
get paid to do it for the most part, but I still do it. So
again, I would think that would not be a conflict.
I think that's why you were asked to serve, Jim.
Okay, well, I just wanted to disclose that. Okay.
All right. Peter, if you would start with an overview of the CLE requirements, please.
Yes, I'm gonna share my screen just so everyone we can all be looking at the same thing. I just wanted to very quickly go over some of the requirements of our CLE program and the purposes of the CLE program. I think it's a good thing to keep it in mind as we make these discussions or have these discussions and make recommendations. So I'm going to go ahead and just share this real quick. This is the Rule 1501, the scope and the purpose of the CLE rules. Really, it is. This is in your materials, but the continuing legal education program is designed to kind of work in tandem with the rules of professional conduct to ensure that the public is served by lawyers who are competent and who maintain high ethical standards. The statement makes clear that in order to render professional legal services in a responsible manner, that you must manage the law practice competently, that you must understand that life and society are changing rapidly and laws change, and that lawyers must have continuous education and training to maintain competent legal services. So that is the essence and the point of continuing legal education. There have been times in the past where we've had discussions on whether the purpose of CLE is to increase professionalism, increase camaraderie, or to increase, improve relationships between lawyers, or to network, or to see other lawyers in a different environment. And those are some tangential benefits, but in terms of the real purpose and scope of what CLE is required, why it's required is to maintain competence and improve lawyers' professional skills. So there are many definitions in the rules, and going through this, I think also shined a light for me that maybe we need to take a look at clarifying and simplifying the CLE rules, because they're very long and in some areas pretty complicated. But if we were to create a definition of a new type of training, I think it would fall into these definitions after the one we created for technology training. And then in terms of what our requirements are right now, every year in a calendar year, a lawyer must complete 12 hours of approved CLE. Of that 12 hours, 2 hours must be in the areas of professional responsibility or professionalism, what we now kind of call ethics credit, and 1 hour shall be devoted to technology training. The way we currently are interpreting these requirements and enforcing these rules allows lawyers to complete a technology training course that could also qualify to be an ethics course or a general course. The technology training is not its own category at the moment. I do think that in terms of a rewrite and with new programming that we're going to be putting in place, that might be something we look at changing. The technology becomes its standalone credit and not a part of something different. It would make it a lot easier. Once every 3 years, each lawyer has to complete an hour of CLE on substance abuse and mental health as defined in the rules. And that is once every 3 calendar years, the lawyer has to do that. And that is in addition to the 2 hours of ethics. So it is not something that would count as one of the 2 ethics requirements. And then the lawyers do have the ability to carry over up to 12 hours of CLE from 1 year to the next. There are requirements for new members that they must take a professionalism for new admittees program in their first year and a half of practice. And any lawyer, and this is not in the CLE rules, but any lawyer who is a signatory on a trust account has to take a trust accounting CLE at least once before they should be signing checks or dispersing funds from a trust account. Those are really the only requirements for lawyers. There are exceptions and ways to not have to take these and be exempt, but those are the basic requirements for lawyers. Some states do requirements that are in a 3-year period. You must complete 36 hours in a 3-year period or 24 hours in a 2-year period and give the lawyer a longer time period to do that. And also that divides up the reporting process amongst the bar. So you only have a certain fraction of lawyers having to report each year. It makes it a little easier to administer. So that's another thing that we can consider at some point with the CLE board. That's a brief overview of our requirements. I just think it's important that we always remember the purpose of CLE to improve our competence and to improve the lawyer's professionalism in the legal field. George.
Thank you. Since word of what we are doing has gotten out within the bar, we've had a number of responses. I think those were included in your mailing. We had a letter from various deans and past deans of the law schools in North Carolina, the Advocates for Justice, the Center for Death Penalty Litigation, the Equal Justice Alliance, and the and we also received a report of diversity and inclusiveness from the 360 Commission to the ABA House of Delegates. Peter, have you received any subsequent responses?
Yes, so I sent out this morning 3 additional letters that we received. I will share them here. We received a letter from the North Carolina Bar Association regarding recommending and supporting periodic CLE on bias and diversity training. We received a letter from the North Carolina ACLU Foundation also supporting this, and from the North Carolina Public Defenders Association, the chief public defender also recommended this change, this mandatory requirement. So there's 3 additional letters in support of a mandatory requirement. I think it's all of them they're very similar in their support in terms of the reasons and for the scope of what the credit might be, what might be considered an approved course. There are a few differences. It does appear some letters support an annual requirement and some letters support a periodic requirement that would be 1 hour every few years. And so that's they are not identical in all supporting an annual requirement, but they all are supporting some sort of mandatory CLE training. Dorothy, do you have a question?
I do. Those other letters that you just spoke about from the deans and all of those different ones, did we get copies of those?
The letters from the deans and the advocates, they were all part of the materials as well. So it should be in that agenda that was sent out with the meeting invitation, should have all of the original letters in. And then we got 3 more that I emailed out this morning.
Okay, I'm sorry. I saw the ones from the
Okay, sure.
today, but not the other ones for some reason. But I'll check back. Thank you.
Okay, great.
Any other questions of Peter regarding those letters? Any comments about those letters?
Just one more thing. Did we receive any letters in opposition by any chance?
You anticipated my next question, Peter.
No, we have not. We have not received any letters in opposition, although I will, my guess is if a recommendation is made and something is published, that we will receive additional letters either in support or opposition. But at this time, we haven't received any in opposition. I've just, based on, I have had conversations with lawyers who generally are opposed to the state bar adding new requirements in any field just because they don't like having their 12 hours taken up by requirements, but I haven't had any official emails or letters in opposition to this process.
Other questions?
There was a new, in terms of the resolution for the ABA, this resolution that was in your materials is from a few years ago. There is Brian is let me know there's a new proposed resolution at the ABA regarding implicit bias training. And if Brian, you have that and would like to share it, I would be happy to give you the screen to do that.
Yeah, I'll be happy to do that. Can you make me a co-host so I can share my screen?
Yep.
And this is a resolution, as Peter said. It's before the ABA House this week. They're meeting virtually, I believe, yesterday and today. So I'm gonna, let me see if I can choose the right screen here. All right, can you all see this? You see a resolution in front of you?
Yes.
So this is actually a resolution from the section of Civil Rights and Social Justice of the ABA that's urging all states, territories, tribes, highest courts, or legislative bodies for both lawyers and doctors to include or to require some type of periodic training about implicit bias. So this is their resolution. I think this may be something that Peter, you could email to the subcommittee after this meeting, because it is, rather lengthy. They have a report here about their findings, talking about the different resolutions that have been passed over time, as well as other sections that have signed on to this statement that other states should be considering, including implicit bias training in their requirements for lawyers and for doctors. So that's kind of one interesting feature here of this resolution. But like I said, this is before the ABA House this week, so we can report back on what the ABA does with this particular resolution.
And we'll get that sent out right away to the group for your review. But I think that review probably trumps, that resolution probably trumps the resolution that's in our materials. But that, at least the resolution in the materials was before the ABA and passed through the ABA. And what that did was recommend that states that require CLE for their lawyers implement some training in diversity and inclusion. At the time is what it was, more diversity and inclusion and not as focused explicitly on bias. And with the caveat that they did not want states to increase their CLE required total hours to add that requirement. And that resolution and the report from that resolution is in your materials, but we'll get this new one out for you to review as well.
And this resolution, just to be clear, this resolution was just recently published. So it's I think I saw a news article about it last Friday or something of that nature. So but like I said, we'll report back on what happens at the ABA.
Was the House of Delegates considering it for adoption or for study or what?
Well, I guess that I don't know what they're going to do with it. I think this is straight from their section, but they have a number of other sections that have signed on to it, it looks like. So I think the proposal is for adoption, but whether or not the House ends up sending it back for further study, I'm not sure. But based on the report that they have, a fairly lengthy report, it looks like it's been studied a fair amount. So my guess would be an up or down vote, but we'll just have to see.
Okay. Thank you, Brian. Peter?
I think it's be a good time since with Brian here to give us an update on what the ethics committee is doing with any potential changes that they're proposing to the rules of professional conduct that may give us some guidance on where we should go.
Sure, I'll be happy to do that. So, and good morning, everyone. The ethics committee met on July 23rd and had a very full agenda, but in that agenda, there were a number of different proposals regarding the rules of professional conduct. I think the most notable recommendation from the ethics committee that was acted upon by the State Bar Council that week was a recommended amendment to the preamble to the rules of professional conduct. Some of you may remember, and I believe this language is in your materials. Is that right, Peter? Did I see that in the agenda?
Yes, it should be in the materials that were sent out on Friday.
Yeah. So the proposed amendment to the preamble, has a fair history. As some of you may recall, the council actually approved an amendment, a similar amendment to the preamble. Stating that one of the foundational responsibilities of a lawyer is to avoid discriminatory conduct. And they passed that back in 2010, but the Supreme Court did not act upon the council's recommendation for that amendment. So essentially, it's kind of been dormant for the past 10 years, but it was brought before the Ethics Committee on July 23rd. The Ethics Committee voted to publish this amendment. This is the language here that would be included in the preamble. While acting in a professional capacity, a lawyer should not discriminate on the basis of a person's race, gender, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. For those of you that may remember I'm going to pause there and say, for those of you that remember the 2010 proposal, this language, is very similar. The real difference are these two last statuses that were included. Marital status and socioeconomic status were included in this version, the 2020 version. The amendment goes on to say this responsibility of non-discrimination does not limit a lawyer's right to advocate on any issue, nor does this responsibility limit the prerogative of a lawyer to accept, decline, or withdraw from a representation in accordance with these rules. So this amendment it was passed by the Ethics Committee and approved by the State Bar Council the next day for publication. It will be published during this next quarter, both on the State Bar's website as well as in the State Bar Journal. And of course, that journal is sent out in hard copy to each lawyer and made available electronically. And we will certainly be publicizing the availability of that journal on the State Bar social media as well as the website. So this is, like I said, probably the most notable action from the Ethics Committee with regards to the rules of professional conduct. But the Ethics Committee considered two additional proposals. One is the proposal to adopt language into the actual text of the rules of professional conduct regarding discriminatory conduct or harassing conduct. Notably, as we kind of look across the country, by our count, there are 37 different jurisdictions, including DC, that have adopted some type of anti-discrimination language into the text of their rules or the comments to their rules. I believe, and I don't have the number right in front of me, but I believe 25 jurisdictions have actually adopted language into their rules regarding or prohibiting lawyers from engaging in discriminatory conduct or harassing conduct. Of course, as most of the rules of professional conduct across the country look like, we have different versions of this rule throughout the different jurisdictions. But generally speaking, these amendments or these provisions that I'm talking about basically prohibit a lawyer from engaging in discriminatory conduct. So that proposal has been put before the State Bar, came before the Ethics Committee, and the Ethics Committee created a subcommittee to have that conversation of whether the text of our rules of professional conduct should contain some type of anti-discrimination language. I think it's important to note that while a great many jurisdictions have had this conversation, and which has resulted in some type of additional language to their rules, or perhaps additional language to their comments to the rules, some jurisdictions had that conversation and decided not to adopt any type of anti-discrimination or anti-harassment language into their rules of professional conduct. So we're going to have that conversation here in North Carolina. And like I said, a subcommittee has been appointed, or will soon be appointed, to begin its study of that proposal. The second proposal that the Ethics Committee is undertaking in the next months is this one that Peter, I think, just had on the screen, regarding the comments to Rule 1.1. Rule 1.1 deals with competency, and the proposal is that there be an additional comment included in the comments to Rule 1.1 that recognizes the importance of a lawyer to be aware of cultural differences and implicit bias with regards to the representation. Understanding that implicit bias can affect the outcome of the representation and can affect the lawyer's ability to represent the client, him or herself, as well as the different cultural differences that may arise between, or may exist between, lawyer and client. And so this proposed comment just encourages lawyers to be educated about cultural differences, potential differences, and potential biases to ensure that the understanding exists of the client's needs, that effective communication exists between lawyer and client, and others for that matter, and that ultimately adequate representation of the client is achieved. So this is going to be studied by a separate subcommittee. Again, just want to be clear, these are two separate subcommittees that are being created, one to study the potential inclusion of anti-discrimination language into the rules of professional conduct, and a separate subcommittee to study whether or not we should have some language in the comments to Rule 1.1 about a lawyer's need to be educated on implicit bias and potential cultural differences. Both of these subcommittees will soon be appointed and will begin their work, and I'll be happy to provide periodic updates as those subcommittees progress in their discussions. I'm happy to answer any other questions anyone may have as well.
Can I ask why there are two subcommittees?
The chair of the Ethics Committee and really the other members of the Ethics Committee felt that these two, there was kind of talk about putting them together and just having them studied by one, but that they really do kind of represent two different ideas, as related as they are. That they, I guess, ultimately they felt that they wanted to address these things separately, just to, I guess, ensure that the conversation, the focus remains solely on each individual idea, and that the subcommittee could bring forth a recommendation one way or the other on each each proposal. But yes, there was discussion about having them both, but ultimately they decided separate would be better.
So you could end up with two independent proposals, or in the end, perhaps one integrated proposal.
That's correct.
But that would be up to the full committee more than likely.
Yeah, I mean, it's always going to be kind of two independent proposals, and you can maybe have, yeah, if both committees recommend some sort of amendment at the same time, I guess that's going to be, the question of when each subcommittee finishes their work. But they will ultimately go to the Ethics Committee for its review, and then if there's some recommendation for an amendment, of course, that will go to the State Bar Council for approval for publication. All right, thank you.
George, you're muted here. Just I'll jump in and just
How about now?
you're good now.
Okay, I had lost the signal. I think a result of the hurricane that got our systems down here. But Brian, thank you for that. Peter, where do we go from here?
Well, I wanted to share, I think this is a good time, certainly a good time for the committee to have discussion on where, you know, what your thoughts are and what you might, where we might be leaning. And I'm happy to share what I think are some of the most, my most preferred options from different states that in different language to look at for as a guide. If the way the committee is leaning is wanting to develop some language to recommend, put them in your materials. I think there's probably there's a set of them that are very similar that are to model off of, and then there are a couple states that have a more unique language to look at. And if the committee would like to start discussing that language, and this is the track we were on, I think it would be a good time to look at that language and just kind of start having that discussion.
All right. You've sent us some language in our materials.
Yes, so I'll show that page here. I think there's Florida and New York have what I consider to be a little bit more unique language than other states that have adopted this. A little more detailed explanation. New York's is a definition that if you look at some of the letters we received from different organizations, they mention the New York language, and you see that there on your screen. It may include, among other things, implicit and explicit bias, equal access to justice, serving a diverse population, diversity and inclusion initiatives in the legal profession, and sensitivity to cultural and other differerences when interacting with members of the public, judges, jurors, litigants, and attorneys, and court personnel. Whereas there's similar language in Maine, Minnesota, and Oregon that is, I think, a lot more would tie a lot closer to what we are proposing to amend into the rules of professional conduct, which, for instance, the Oregon one, in order to be accredited as an access to justice program, an activity shall be directly related to the practice of law and designed to educate attorneys to identify and eliminate from the legal profession and from the practice of law barriers to access to justice arising from biases against persons because of race, gender, economic status, creed, color, religion, national origin, disability, age, or sexual orientation. One common item to all of this language is that the programs must relate to the practice of law, and I think that's a good idea to have that language in any sort of definition that we might draft. Other than that, I leave it to the committee to discuss what their preferences are and what they like or dislike about these different definitions.
All right. Let's go from there. Has anyone in reviewing these definitions by jurisdiction found anything in there or that is particularly laudable or that they think should be deleted?
I have a question, excuse me.
Yes.
I apologize for missing the other meeting. Has the committee yet had a discussion about how to structure this requirement? Have I missed that? Did I miss that? Or was a decision made on that?
No, that's a good question, George. Good question, Dixon. I think that is another part of this would be how it would be structured. I think that there's two avenues we need to go down. One is defining what it is we would be requiring, and two is how would we require it, whether it's annual or periodic. That's a discussion and a decision and recommendation this group has not made yet.
I don't guess it matters really necessarily which one we take up first. Seems that we might, my mind sort of goes more to the procedural than it does to the substantive first, but maybe Mr. Wilson joins me in that. I don't know.
Might I ask a question about the possibility of considering some of the language that the Ethics Committee of the State Bar is considering in terms of the descriptive items that are listed on this proposed, professional conduct rules? Is there some reason we shouldn't perhaps use much of the same language?
I think that's a wise idea, Chief. When trying to come up with some proposed language, pretty much took the classes that were identified in the preamble and the language in the preamble to do a mock definition of what access to justice training would mean. I think tying it to whatever language is passed by, if any, is officially adopted by the council would make a lot of sense, that the language is at least similar, or if not a mirror image of the same language. Dorothy, you had your hand up.
Yes, I agree with that, that the language should mirror. I know that we're kind of tracking along the same, with the different subcommittees that will be working on that end. But I would want us to definitely include, as far as the requirement of the hours, to be involved in the, diversity and inclusion, as well as elimination of bias. Like, I'm very concerned about all of that being included in the requirement and not just one or the other.
This is Jim. It's as one who teaches about bias, specifically, not the broader context sometimes of diversity and inclusion. It seems to me that the narrower you define it, the harder it will be to do something every year. That's if you imagine lawyers going every year to CLE, you want it to be things that educate them and inform them and connect with them, and you don't want it to be one of those things that they say, "Oh, I got to do that again." So there's a tension there. I mean, if you talk about elimination of bias, I've devoted much of my career to trying to do that, so I'm a big fan of it. But I think we do need to be conscious of when there is a definition. If it is something that's done annually, then to use a different word, there needs to be a diversity of items within that requirement that people can go to and still find it to be worthwhile. And I'm not right now expressing an opinion about that, but I do think there is a tension there. I think bias is really critical, but this whole question of fairness or access to justice in a non-discriminatory way has many facets. And the amount of time is another thing that when you get to the details, it's hard to eliminate bias in an hour, but nonetheless, it may be, given the limits of time that we deal with, that may be the best choice if that's where you go.
Looking at the issue of time, if we set a minimum that's required each year, that certainly wouldn't prohibit a course from being 2 or 3 hours, and in fact, probably that would be necessary. But the minimal requirements to just expose lawyers to the need for bias sensitivity training and for diversity education, I think would be, we just have the minimum, because candidly, and at least in my area, there are going to be a lot of lawyers who are going to object to it, and who are not going to want to participate unless required. It may be that those who need it the least would be most likely to take the 3-hour course or a 2-hour course.
If I could just jump in, I think Dixon is very wise that it's hard to have a great discussion on what the substance of language would be if we don't have at least an idea on what procedural requirement we might have. And just so I can frame some ideas, I think we need to we should have a meeting that focuses on the procedure. But one thing I've been throwing around is the idea, since we are working on developing a brand new CLE database management program that would allow us to reprogram and rethink some things, that perhaps as a state we should move to a 2 or 3 year window of CLE. That is, for instance, if it was a 3-year window, you could have lawyers required to take 36 hours in a 3-year period. Amongst those 36 hours, a certain amount has to be in a couple of different categories, and it allows the lawyers to take it when and how they want, instead of it being a 12-hour annual. You could have 36 in over 3 years. 6 of those must be ethics credits. 1 or 2 has to be technology. 1 or 2 has to be substance abuse, and 1 or 2 has to be an access to justice credit, if that's something that we were thinking about. It might be easier for lawyers and easier for the bar to administer than to have either changing annual requirements or an annual requirement of 3 specific types of training hours every year that takes up a lawyer's ability to get that full training in their area of practice. So, I mean, those are things that we can consider and recommend, and that we could work to rewrite. That's certainly still early on in imagination, but I don't think we need to, I think it'll be hard to kind of get to that today, since we didn't prepare and send out options and materials for how we would do annual or periodic training. And so maybe we need to get to that again before we finalize or come to some more agreements on what you want to do in terms of definitions. Dorothy?
I'm just trying to make sure I'm calculating this correctly. Of the 12 hours each year, say we're in the year of the every 3 years with the substance abuse, that particular year, a lawyer would have to have, they would only have, it looks like it's 7, well, they have 7 credits that are already accounted for. Am I right? That's 2 hours of PR, 3 hours of ethics, 1 hour of tech.
The PR is the ethics. So
Yes, I'm sorry. I don't know why I wrote that. Okay, so it'll be 5 hours from that.
Right now we allow lawyers to take a technology credit that could be also counted as an ethics or general credit. But if we were to create technology as its own credit column, then the lawyer would have to take 1 technology, 2 ethics, and 1 substance abuse. And then if we added another annual requirement, that would, you're right, that would create 4 or 5 out of the 12 that would be required, that you know, in theory they are not using to get the training in their area of practice.
But that would just be the every 3 years with the substance abuse.
That's right. If that's 3, it would just be 4 every year. That's right.
Peter, are you suggesting that maybe we need to have a separate meeting about the procedure and the details of the rule at a later time, and today talk about the content, proposed content of the rule?
I think I would prefer that, George, just because I'd like to get the committee some options and draft up, allow the staff to draft up some different options to look at, instead of kind of winging it here in this meeting. If we were to come back in a few weeks with a meeting that focused on a procedural recommendation, that'd be my preference.
Any objection to proceeding that way?
Barbara, do you have your hand up?
I just had a question that, you have several courses listed that are already being offered on implicit bias. Are all those ethics credit right now?
Yes, you would get ethics credit for those courses now, and we do approve those for ethics credit.
Okay, so without any standalone provision, people would just be taking it as part of their it'd meet their ethics requirement.
Yes, it would. It would meet their ethics requirement, and they can do that now. It's just whether or not we want to require it. Right.
Yeah. But, okay. Answer my question.
Technically, it's a professionalism. They're professionalism courses, Barbara. CLE is kind of weird math, and professionalism equals ethics. But we've approved those courses for a long time under the definition for professionalism. Just to follow up on what Jim was saying, I really encourage you to have a broad definition of any mandatory requirement that you have, which allows the providers to be really creative, and it helps to avoid some of the backlash that we have gotten over the years for the mental health mandatory requirement, for example, where lawyers say, I've been going hearing the same thing year after year, and I don't need to hear this over and over again. So I really encourage that you be broad and maybe be not so specific, to be inclusive in the definition itself, to allow for creativity, and also to allow for things over time to evolve. And there may be things 10 years from now that in this area we want providers to focus on that we're not anticipating now.
Yeah, I thought Jim's comments on that and Alice's comments were very good there. Looks like in the supporting letters we've gotten, and also in the ABA resolution, appears to sort of emphasize both diversity, inclusion in the legal profession on one hand broadly, and then the elimination of bias or discrimination as sort of two broad elements. Another question there then is, would we include any sort of laundry list of bases, inappropriate bases of bias and discrimination? I sort of like the way the New York rule is written, that does not include a list. And the virtue of that is, on the one hand, that it would accommodate Alice's point that things do change. And also I have a little bit of resistance to equating such, marital status with, race, given the historic distinction of racial and ethnic issues as a basis for bias. I'm not advocating particularly a way to deal with that, but I did want to note that, and I think that might have been somewhat reflected in James Williams' comments that he submitted, that the race, because of its history and everything, is particularly an issue. So those are just sort of random comments I'll put into the discussion.
I just wanted to add that I think it is important to have a broad category, as Alice suggested. I think the first implied or implicit bias course that I actually attended and heard was about 4 years ago. And I remember I was fascinated with the concept the first time because it was entirely new to me. But I would like for the categories to be broad enough so that it doesn't get become a worn record over time, and that there are a number of issues there that can be explored in a number of different categories.
And I do think that if we were to move towards a broad definition of this type of course, we could have that discussion without knowing if we were going to have it be an annual or periodic requirement. If that's a good idea to have it be broad, then I think we could have that discussion regardless of knowing the procedural requirement.
I agree.
In the materials, I did also include a list of courses that if you did a search on our CLE directory for bias, then there are a lot of courses. Many of them are on-demand courses for potentially national providers, but there are a lot of available courses, including Star Trek: Elimination of Bias, which I now just see, that are already available for lawyers. So I have that in there to point out that I don't think we have an issue like we had with technology at the beginning, where there's going to be a shortage of courses available for people to take to satisfy this requirement. I think there are courses that have been consistently been approved and offered over the years because it has qualified for ethics and professionalism credit that are available. And so that's a bonus that we have going in our favor, is that there are these courses out there already. It would just be that they would be now required for lawyers to take.
There are a lot of people who can talk about this. And there, 15 years ago when I started, there weren't very many. It is now, it's widely available. Every major corporation in America has programs. And many other institutions do, educational institutions. So I agree with you, Peter. I think that capacity is not going to be your problem.
Peter, did you say you drafted something?
I did this morning. I'll share it with you, but again, this was just very, it's not in depth yet. I was thinking about how to make it a 3-year, if we were going to shift our rules to some sort of 3-year requirement, which is way too early to have a decision on that we could have something like this, where out of 36 hours, you have to have 6 hours of professional responsibility or professionalism, 1 hour of technology, 1 hour of instruction on mental health and substance abuse, 1 hour of access to justice training as defined in the rule. And then I took the rules from Oregon that included different classes that just said an activity directly related to the practice of law and designed to educate attorneys to identify and eliminate from the legal profession barriers to access to justice arising from biases against. And then I used the classes that were from the preamble that we have published. Again, I see the value in a more inclusive rule like New York's as well. So that's just kind of what I was spitballing when I was thinking about that last night and this morning. I think if the committee is inclined towards the New York model or something akin to that is a more broad definition of the types of classes, then we could come up with some proposals for you to look at, if that's the scope we want to go with, or if the committee wants to to draft it itself, I think I'd be happy to provide some go-bys and a couple proposals for you to look at that we could look at the beginning of the next meeting and nail down an idea on what a definition might be before we move right into a procedural question on how it should be required.
I like,
Barbara,
I think
Barbara,
have some options. Yeah.
You have a motion, Dixon?
I just made the comment that I think having some actual options to look at
Okay.
would be progress and helpful.
I agree. I'm just kind of pondering the difference, just the look of it with it being titled Access to Justice Training versus Diversity and Inclusion and Elimination of Bias. I do think that it is important to have that access to justice training language in there, but I think it's especially important to have, at least this is my gut reaction, that the title be Diversity and Inclusion and Elimination of Bias. Because the access to justice, while it definitely includes what we are concerned about when it comes to clients and dealing with the public, the title of Diversity and Inclusion and Elimination of Bias kind of deals with us overall with access to justice, but it also includes just as a lawyer in general and dealing with each other or dealing with anyone and not just dealing with clients. It includes all of that. So I am, I feel very strongly about that title. So that's what I love about the New York example, the New York language the most. I definitely agree with Mr. Drennan and Alice about the being broad. And I think keeping the categories broad is definitely important too. But I just wanted to note that about the title itself, because I don't want it to appear as if we are not wanting to call it what it really is and what it really should be about, and calling it what it really is. And this is what we really want to focus on.
Judge McGee?
I agree wholeheartedly. I think that those three words, those three phrases simply must be the beginning part. I've been an advocate for access to justice all my career, but I think that's not exactly what we're talking about. I think we're talking about, as you were just saying, diversity, inclusion, and elimination of bias. I think that needs to be our focus. And I personally would like to see us have at least a requirement of 1 hour a year. I don't know how we wait 2 or 3 years for someone to be able to begin to focus on these issues. I know it takes a period of time to get through the process, but I would like to see us seriously consider, making it mandatory for at least an hour every year. I know that's going off track exactly, but I feel pretty strongly about that too. We just can't wait.
My understanding was that we had talked about having a one hour per year requirement. And if we go to the 36 hours over 3 years, then certainly the required time should be at least 3 hours. And it would seem like it needs, at least as we implement the rule, it should be front loaded, that it should be required at the beginning of the rule and then thereafter can be spread out.
As much as I like the idea of a broad, inclusive definition, it has to emphasize bias in the language, not exclusively, but I think it has to be in there. I don't know whether it should be in the title or not, but it definitely has to be an important component of what your definition is talking about, in my view. And this 36-hour thing sounds fantastic, but if it's years away, I agree with Judge McGee that you go with what you need to do now, and then when you roll out your new plan, it would be really nice to have that flexibility, because frankly, a 3-hour block every 3 years is likely to be much better than an hour every year. But that's not, you got to have that as a possibility in your system. And I understand you could always do a 3-hour block and people can come if they want to. They just only need, depending on how you write your rule, you may only need an hour for that year. But nonetheless, I mean, people voluntarily come to these programs. I mean, I've taught them, they voluntarily come to these programs. So I would not want to foreclose that.
We could do that. And I was having the same thought about not, if we're going to do it, go ahead and getting on with it, as Judge McGee was saying. But we could, I don't think that's inconsistent. I don't think the idea of having the 3 hours every 3 years and a minimum of 1 hour a year are mutually inconsistent. It could be structured so that you'd have to keep a credit of at least 1 hour a year going, right?
Yeah, it's certainly possible, Dixon. I think that creates some more programming and administrative difficulty to have to be able to track the annual in a. But again, we can make things work. Just as a reminder of the timeline from how even the earliest possibility I think that this could be in place is the 2022 CLE year. Just because if this proposal goes to the CLE board in September and the CLE board were to recommend it to the council, that would get, and the council agreed with that recommendation, it would be published for comment after the October meeting, and then earliest it could be adopted by the council is in January of 2021. And so the CLE year would have already begun, and we don't add this into once a CLE year has taken effect, because we also would have to wait for the Supreme Court to approve the rule. So I think we would be looking at January 2022 at the earliest that this would become effective if everything aligns and moves appropriately.
Well, we are in some ways getting into a procedural discussion, but the proposal you've made with the 36 months would be a complete overhaul of the CLE program, whereas the 1 year diversity, inclusion, and elimination of bias requirement could be started immediately, January 2022. And then in the meantime, work on the block planning system.
Yeah, so I think what might be best for this committee is to leave some flexibility in your recommendation, however we want to do the recommendation, to allow for the fact that there might be structural change for the CLE program, but not to guarantee, we don't know for sure that there will be. So however the recommendation is drafted from this committee or the CLE board needs to understand that it's possible that the 12-hour a year requirement could still be in place, or that we might have some structural change. However, we want to draft some sort of recommendation, because all of these things are happening kind of in parallel now, and so it's hard to know when and how things will be completed, because we're going to be working with a company to do this restructuring this year, and it'll go into early next year, and so all timing is we can't kind of stop one while we're doing the other. We need to be working on all of them at the same time. But in terms of the substantive, what I think is the best next step would be to take the advice from this committee to work on a broad definition, understanding Dorothy and Chief Judge McGee's comments on the title and the language of the rule, and come up with some options for this committee to consider at its next meeting. I think using the New York rule as a go-by. I did have one question for the committee. Is the New York rule does not list classes, and our preamble will list classes if that were to be adopted by the council. is there any, does the committee not want to include classes, or do they want to leave it out like the New York rule?
Anyone?
I've drafted a lot of statutes, and often there is an including but not limited to format in doing that, where you want to emphasize certain things but not limit so that's one possibility as you're drafting that. And if it becomes officially part of the preamble, I mean, that puts some extra impetus to making sure that your CLE rules sort of track the aspirations and mandates that you expect of lawyers. So I can see what you might be able to work in the classes or categories of discrimination and bias you want to eliminate. Just not limit it to those categories would be my general approach.
I definitely agree. I think it's important to include those classes and at least mirror what we are doing on the other side.
So some sort of hybrid between the two types of rules that we've been looking at, where the New York model is broad in what the courses could relate to and include, but the Oregon model, adding some classes of persons that we should be learning about. And so I think that's some good guidance that we can come together to give you 2 or 3 proposed options to look at.
Sounds good to me.
So Peter, could you draft up some things, some proposals, and send to the various members of the committee?
Yes, I think I can do that in pretty short turnaround time. So if George, depending on everyone's August, if you want to do a meeting in a few weeks, then I think we can do that and continue to move this thing forward. And obviously would love to hear and receive any proposed drafts or suggestions from members of the committee or any of the members of the public who are watching.
Do you think
And is the goal to have something ready and it'll go straight to the council for the October meeting?
The CLE board has a retreat at the end of September. So the goal would be to have something to present to the full CLE board for consideration. Okay. They could have something for recommendation to the council in October.
Okay. Hope so.
Peter, would 2 weeks be pushing too hard?
It might.
Okay.
The world right now, I think we all kind of operate at 2 weeks at a time. I could probably, maybe the 25th might be a little bit more doable, George. 3 weeks.
The 25th is a bad day for me.
Okay.
The rest of that week is good, but I don't know of other schedules.
If that's a week that the committee would like to meet, then we can send some options out for the committee, and we'll go through that process to determine the right time for everyone to meet if that week works. Unless that week is completely ruled out for somebody, but if we can find a day or two and some times that work, we'll meet that week.
Is that agreeable to everyone? Thought I saw a thumbs up from Professor Drennan.
Yes, that's good.
And from Dixon. All right. Why don't we plan on that? If you would maybe get us a draft of a couple of proposals, and then at about the same time send out a survey of available dates.
Sounds good. We'll do that. A draft of proposals and some options on for the committee in terms of language on how it might be required and how often it might be required.
All right. And then to go to the procedural aspects, do we want to consider that during the next meeting, or put that on the back burner maybe to the first week or two of September? Get the language that we want first and then look at the procedural aspects.
I can have some options prepared for the next meeting, and depending on the length of time that it takes for us to look at the substantive language of the definition, then we can either move to procedural, or we can come back and meet in early or mid-September to nail down that recommendation.
How does that sound to the committee members?
That's fine.
Okay, Dixon, okay?
The idea being to have 2 meetings?
Potentially have 2 meetings
Yeah.
if we run long on the
Yeah.
the theoretical, then
Yeah, I think there might be 2 meetings if we're trying to keep the meeting short like we are this morning.
agreed. All right. Then Peter, if you would take care of that for us.
Absolutely.
Does anyone else have anything to offer, either for the group to be considering before our next meeting, or to consider for today?
May I make a
George,
general comment?
All right, who was?
Judge
Sorry,
McGee?
Judge. Feel
Yes.
free.
Well, I know the timing and the process is extended. That's a given. But I am delighted to see that we're already getting responses from, major leaders within the bar saying that this is something that needs to be done. I know that time frame gets to be longer than we might like, but we certainly have a wonderful bully pulpit we can make use of, during the next year and a half before that takes place. We can begin to encourage the providers, for instance, to begin working on, our more, North Carolina providers to be working on programs, and to go ahead and put them on their programs, talking about these same kinds of issues. I think we saw that when we made the technology changes. They began to develop something quickly and improved their focus on that. I think we need to try to encourage them to do exactly the same thing this time around. Go ahead and start putting it on your agendas, and have discussions about it. I hate to see us lose that time frame without making it clear that this is something important that we expect to occur.
Thanks, Judge.
Great.
Thank you, Judge. Anything else?
George, I was just about to tell you, and I hate to follow the chief's very good comments there with such a tangential comment, but the adoption, or the resolution that I had previously mentioned from the ABA, it looks like it was adopted yesterday evening. So the ABA adopted a resolution urging workers in law and medicine to get implicit bias training. So it seems that this committee's goals are right in line with what the national trend is, at least from the ABA.
Can you send that resolution when you get your text?
It
Well,
says,
I've got it now. I'm going to send it out to the group as soon as we're done.
well, and I'll
Excellent.
tell you, this is on the ABA's Twitter feed. It says that it was revised. I don't know what the revised version is, but I'm going to try to hunt down that revised version, and I'll send that over to Peter for dissemination.
Thank you.
Very well. Thank you, Brian. Any other comments from any of the members of the committee or any of the participants?
Nope.
None appearing, I will declare this meeting adjourned, and thank you all very much for your attendance.
Thank you.
Thank you, everybody.
Y'all have a
Thanks
great day.
Very much.
Gray, good luck with